Hello, I'm Frances Deegan Horowitz, President of the City University Graduate Center. Welcome to Women, a series of programs for and about us. I'm delighted to welcome Julie Blackman to the program today. You may not recognize her name, which is just the way she likes it, but the results of her work have been very much in the news. She is a social psychologist who works exclusively now with trial lawyers. She helps choose jurors. Her most recent high-profile case, Martha Stewart. She's had several careers in her young life that have led her to this one, and a fascinating one it is. Welcome. Good to have you here. Where did you grow up?
I grew up mostly in New Jersey. I went to high school in Paramus.
And then college?
I went to Cornell as an undergraduate, and it was a time when you could major in anything you wanted. It was the early 70s, and I did an interdepartmental major in something that I called Contemporary American Personality. That was a combination of psychology, sociology, government, and English. Turns out it served me well along the way.
And what led you to ultimately choose to become a social psychologist?
Well, I was interested in psychology and sociology, and when I was sort of toward the end of my freshman or beginning of my sophomore year, I thought to myself what a great idea it would be to combine these fields and turn them into something called social psychology. I thought I'd made it up, and then I discovered that I hadn't.
And where did you do your work in social psychology?
At Teachers College at Columbia University.
And when you finished, what path did you envision yourself on?
Well, I grew up in an academic family, and so I figured that would be what I do, and I applied for academic jobs, and I went to teach at Barnard. I just moved across the street on 120th Street.
And what was your interest then?
I was primarily interested then in understanding injustice. I took a position there in psychology of women, and was interested in thinking about the injustice that women suffered when they were victims of violence in their families.
But you ultimately chose not to stay totally within the academy.
I did. I stayed at Barnard for about 10 years, and I taught a little bit after that at Sarah Lawrence and at the New School. But early on, I was doing research on domestic violence because I had this interest in intentional injustice. And people interpret injustice in many different ways.
What do you mean by intentional injustice?
When someone deliberately hurts someone else. I mean, you can feel that you're a victim of injustice if you suddenly become sick, or if something bad happens, but it's not a real injustice. It feels, why me? It's not fair, but no one's intentional act brought you to that point. But domestic violence, people's intentional, deliberate acts cause harm to others. And I was interested in how people understood that, how people coped with it. I did research in the late 70s and early 80s looking at victims of violence and comparing them to people who only experienced conflict in intimate relationships. And very early on in that work, lawyers made their way to my door and asked me if I would come and testify as an expert witness in cases involving battered women. And I began to do that in 1980.
And what does that involve when you do that?
Well, it involves meeting the woman who's been charged with a crime. Most of the women for whom I testified were indicted and tried in the deaths of their abusers. They were homicide trials. Most of those women were incarcerated prior to trial, so it involved going to the prison, meeting with them, gathering information from them about their life experiences, and matching that against theories in psychology about the effects of domestic violence. And in the late 70s and early 80s, there wasn't much. I mean, I remember going to a conference on family violence where someone said you could read the literature over a cup of coffee. And it was.
But I think most people would say if somebody's in a violent relationship, why don't they just walk away instead of becoming violent themselves?
This is exactly why expert testimony is so important, because the average layperson, I think, might say that, and yet it's extremely difficult to leave abusive relationships. They're engaging, they're addictive, they're the kinds of things the women think about them all the time. Am I going to be safe today? What's going to happen when he comes home? What can I do to prevent it? And like most acts of survival, where you're working hard to survive, it's not just easy living, it's very hard to be creative about alternatives.
Why not just leave?
Well, the risk to women who leave is much greater than the risk to women who stay. I mean, the statistics suggest that a woman who leaves a violent relationship is something like 11 times more likely to be killed by her abuser.
Because the abuser begins to stalk her.
Stalk her. And also these women are kept in place by threats not only against them, but against members of their family. If you leave me, I'll kill your mother. If you leave me, I'll stalk the children at school. You'll never see them again.
So in a sense, there's almost no way out.
It's very difficult. I mean, there are treatment programs that are helpful. There are batterers who are mandated by the courts into treatment programs, and that can be helpful. But it's a lifelong endeavor. I mean, the mandated programs are 12-week programs. And people are raised with violence in their homes when they're children. It's the best predictor of violence in adulthood. And so people grow up with an expectation that that will be part of family life, women and men. And getting people to understand that it shouldn't be that way, and that there are other important options. It's an educational process.
And does the education work, or do the emotions become so overpowering under stress that the education just sort of goes out the window?
Well, I think it's a different kind of education from classroom education. It's a kind of education that has to do with exposing people to alternatives, so that people who've grown up in violent families get to see families that are not violent. And it's about liaisons between nonviolent families and violent families. It's the willingness to reach out and maintain over time ongoing relationships with women, children, and men who've been in violent families, to offer them the kind of social support that nonviolent families typically enjoy. And one of the things you see in nonviolent families is a network of social support. And yet, when you look at violent families, often you'll see a young woman, she's 19 years old. She has 2 children. She has no access to daycare. She may have a mother who's still raising young children herself. The man may be out of the family, or she may have men who are not the fathers of her children in and out of the house. Those are extremely dangerous settings, and anyone could tell you that. Like, you didn't need to do the research to know it. But I think one of the things we're seeing, and there are programs all over the city that work on this kind of activity, is making effective social networks.
And what is the evidence that they work?
The evidence that they work is limited in part because our interventions are still relatively new. And it's something that we're going to track over the next 20 years when we look at the next generation of women who are getting social support through programs like Steps to End Family Violence here in New York City, which is a wonderful program where women and their children can get treatment and can be social resources to one another, can offer the kinds of social support that's more common in extended families, where your mother will help out if you need a babysitter one day, or grandma can come over and help, and that or siblings are involved, or friends, people who have more resources, who don't have constant demands just to keep themselves alive and intact, are able to be social resources to each other.
But are families that are nonviolent wary of getting involved with families that are violent and afraid of the contagion factor?
They are afraid, but that's a shame, because the only way, this is the kind of contagion you end by getting close. Other things, you avoid disease by staying away, but family violence, the only way you can end this disease is by getting close to people who experience it, so that you can be a resource in their lives.
And what do you have to do to persuade a family, a nonviolent family, to get involved in something like this?
Well, usually it can come in through, relatively simple ways. Kids who go to, schools where there are other kids who are in need. Your kid can become a friend with a kid who's in need. I have a friend who every year when she makes a birthday party, it's not just for her son, it's also for his best friend, whose family doesn't have the resource to make him a birthday party, who, when he needed tutoring, arranged for him to be tutored. There are people who are in my life who I've come to know over the course of a lot of years of living and working in New York, who I maintain friendships with, reach out to, try to keep their resources higher than they would be if I weren't part of their life. You got to be willing just to reach out to people who have less.
And let's say someone's watching this program and they say, I'd like to do that. How would they get involved?
Well, there are all kinds of social action organizations. They could reach out to Steps to End Family Violence here in New York, and they're listed in the book. And I imagine have a website, although I haven't checked their website, but I bet they do. The Osborn Society is an organization that reaches out to people who've been recently released from prison, looking for making themselves new lives here after incarceration. Those organizations, the Fortune Society, there are lots of groups around. There's a group of lawyers. In fact, there's a dinner Wednesday night for lawyers. I'm trying to remember the name of the organization, who mentor teenage kids in high school. And the lawyers themselves participate as mentors. The Capital Defender Office in New York City, one of the attorneys there is involved with that program. and she's someone you could speak to. She would know all about it. Her name is Glenda Grace.
And how long were you involved with all of this?
I started in the late 1970s, and I'm still involved.
And at what point did you become involved in the whole process of jury selection, and why were people interested in you for that?
The second question's harder than the first, but the first question, in the early 1980s, I testified at a trial of a battered woman who killed her husband. He had picked up their infant son by the ankles and swung him out the window, threatened to drop him, and the wife killed him when he brought the baby back into the apartment. She was tried in Brooklyn. I testified at her trial as an expert witness, and she was found not guilty for reasons of self-defense. Her attorney was interested in the kinds of things that psychologists could do in the courtroom. And the next time he had a case go to trial, which didn't involve a battered woman, he said, "Come help me pick the jury." His name was Mike Dowd. He's an attorney here in New York still. And I did. We went and picked a jury together, and it was a criminal case. His client was found not guilty. And he then began to refer me to his friends. And pretty soon there were lots of people calling to ask if I would help participate in jury selection. I stayed at Barnard. I was still doing that work until 1987. So I was still pretty actively involved both in academia and as an expert witness and as a jury consultant. I left Barnard in 87 and continued with the forensic, the legal side of my work, the sort of two-sided life as a expert witness and an author. I wrote a book about the differences between violent and nonviolent families, and began to do more and more jury consulting, and then more broadly trial consulting, because I saw a real need for better teaching in the courtroom.
So how do you approach someone asks you to help them select a jury? What is the first thing you do?
First, I learn about the case. I try to find out, what are the things that you'll hope that jurors believe at the end of the case. And most of all, I work with the attorneys to help them become more effective teachers. Because actually there's very little to do with regard to influencing. I think there's the notion that jury consultants influence jury process, and that's just not so. You have the opportunity to say no to a few jurors, and then the people who are left will decide the case. Both sides have the opportunity to say no to a certain number of jurors. But the bigger press for good trials, where justice can happen, is clear teaching.
And what do you mean by clear teaching?
Well, imagine that you're getting up in front of a group of 12 people, and at the end of your talk and someone else's talk, they're going to make an incredibly important decision, those 12 people. And along the way, they will never be permitted to ask you a question. So if things aren't clear to them, if they hear a witness testify but they don't understand it, if they listen to an attorney's presentation but are unsure about what the attorney was trying to convey, they don't get to ask.
Well, don't juries get to send out questions?
That's during deliberations. But during the trial itself, and there's a project ongoing now called Jury Innovation, Courtroom Innovation, where they're pressing for the opportunity for jurors to be able to raise their hands and say, by the way, that last witness was opaque to me. Could you please tell me, what was the point of that testimony? But as things stand now, they sit silently. So they're the most interesting and powerful learners we have.
What would it take to change things, to say, I can raise my hand and ask a question?
It's essentially judicial discretion. There are some judges who will allow that kind of thing to go on. I've seen judges permit jurors to write down questions and then pass them to the judge, and then the judge determines at the end of a witness's testimony whether or not those questions are appropriate and can be asked. And if he or she makes that determination, they'll be asked then. Of course, it may be 2 or 3 or 4 hours after the event that triggered the question. It isn't in the moment, but it's better than nothing. Jurors may also, depending on the discretion of the judge, be permitted to take notes or not. Although the standard instruction, believe it or not, for jurors who are permitted to take notes is this. They're told, you may take notes if you choose to. However, we found that it often interferes with people's ability to remember what's happening. And in no case should you allow yourself to rely on the notes of another juror over your own memory. Don't rely on your notes. They won't help you. Okay? I mean, anyone who's ever gone to college knows that note-taking is a pretty good idea. And yet I sit in courtrooms all the time. I listen to judges tell jurors, not so. don't do it.
Why? Why do they do that?
Well, they have a transcript. I think they prefer that the jurors rely on the transcript. I think there's the concern that good note takers may become overly powerful. There's an effort to keep jury process democratic in a kind of rectangular way with no one rising above the group. Of course, that's not possible. Any group of 12 people has some people who'll be leaders and some people who won't. There's no group of 12 people where everyone talks the same amount or contributes the same to the result. It's a social psychology, sort of useful on group dynamics. And so, there are lots of ways in which the court seems to have an ambivalent relationship with having jurors be fully informed. And of course, there's a tremendous amount that goes on out of the presence of the jury for legal reasons, where they're prohibited from hearing certain aspects of things that the lawyers wish they would hear, at least lawyers for one side.
Have you ever served on a jury?
I have not. I was voir dired once, which is asked the questions that are asked before jurors are seated. And the question asked, have you had any experience with the legal system? And so I said I had actually had some experience with the legal system, and that I had testified as an expert and worked as a trial consultant, and my husband is a criminal defense attorney. My sister-in-law is a prosecutor, so I thought perhaps I had things balanced. And the judge said to me at the end, well, Ms. Blackman, do you think you could be fair? And I said, I do. I think I could be fair. He said, well, then I'm going to seat you, and we'll see what the attorneys think. But before I got to my chair, one of the attorneys said, I don't think so. And that was as close as I got to serving on a jury.
Well, in terms of jury selection, even though, in a sense, each side is only allowed a few disallowances, what do you advise lawyers to look for in accepting a juror and not accepting a juror?
Well, actually, I have the view that prejudice is a very serious thing in courtrooms, and that the most important thing to do in a courtroom in order to serve justice is to try and ferret out those people who have prejudices that are relevant to this case. I think there are people who have class prejudice that go up and down. There are people who are prejudiced against the wealthy. There are people who are prejudiced against the poor. There are people who are prejudiced against people who make too much money, even if they came from humble beginnings. There are people
So do you tell the lawyer that, and then the lawyer assesses that, or are you part of the process of assessing whether somebody has a prejudice that will go against the lawyer's client?
I'm part of the process. In federal court, and most of the cases I work on now are in federal court, the judge conducts the voir dire. Voir dire is a process. The words, they sound like French, but actually they're a sort of degraded version of Latin, veritas dictum, to tell the truth. The jurors are sworn to tell the truth, to reveal information about themselves that is relevant to the trial. It's not prying for prying's sake, but it's for the sake of seeing whether or not these people can fairly serve as jurors.
So if the judge is saying tell the truth and the lawyer is there, what's your role?
Well, if there are questions that are asked of the jurors, often I'm the one to help design the questions that are asked. And then I listen to the answers.
And then you say to the lawyer, yes, no?
Yes, no, right? Or, it's a collaborative decision. It's not something I do all by myself. Typically, usually the lawyers and I and the client are all a part of the process. And we try to make decisions that are reasoned, that are based in some reason, that aren't just random, but you don't have many opportunities to say no. It depends on the case. In certain cases, the highest that you get, I think, is 20. But most of the time, you have 10 opportunities, or I just picked a jury recently, we had 4 opportunities to say no. And sometimes in civil cases, it's only twice. You get to say no twice against a group that will ultimately be 6 jurors.
Well, a jury, in our system, is supposed to be a jury of your peers. Mm-hmm. To what extent does that really happen in terms of true peers? Take Martha Stewart, for instance. Was that a jury of her peers?
I think it was a jury of her peers. I think I have a slightly altered definition, maybe, of peers. It's the people that you would want to serve on the jury if you were on trial. It's people who you would be comfortable having, as comfortable as you can be if you're on trial, having people sit in judgment. And I think the people who served on Martha Stewart's jury, and of course there's a notable exception in her case, because there was a juror who did not take his vow seriously and did not tell the truth. But with that caveat, I think those people were people who listened hard to her case and worked hard with the information they were given.
And do you ever come to any personal conclusions as to whether the person on trial is guilty or innocent, even if they're protesting that they're innocent?
I mean, I have personal reactions to people that I work with, but I have great respect for the province of the jury. It's a respect that grew for me during the time where most of my legal work was expert witness work. I don't tread on the jury's province. I give them information to help them make a decision. I mean, I think we're living in a time now where too many people are being indicted. And so there are a number of people who are indicted in criminal matters that historically would have been handled as civil matters. And I think that that's a shame, that there's something of there's an overly aggressive, in my view, criminal activity at all levels. I mean, we're incarcerating too many people across the board, poor people, rich people, and between people. I mean, we incarcerate people here at a tremendous rate.
We have the highest percentage of incarceration of any nation in the world.
Right. And to what end? And with what messages that we send about kind of the nature of our society and the importance of problem solving in ways that are somewhat more creative and expansive than just locking people up, which is, of course, the most expensive thing that society can do, and is, for many people, for most people, the most social service they're ever going to get, when a lot less social service earlier on would have made a big difference for them. So,
yes, one often compares the cost of tuition into City University of $4,000 or $5,000 a year to $67,000 a year to keep somebody in a prison cell.
That's right. And education is clearly the thing that most sets people free, because it gives you a chance to envision your alternatives and to make them real. Of course, you have a program here that's doing wonderful things for women in prison.
But it would come back to the issue of education. You say the goal of your helping lawyers is to make them better educators of the jury. How do you do that?
I work very closely with them from the very beginning of trial preparation now. In most cases, we identify the themes of the case. What are the things that you hope the jurors will believe when you're all done? How are you going to persuade them? And how can we teach them what they need to know? A big part of my work over the last 15 years has involved patent cases. My office is at a patent law firm, Fish and Neve, one of the oldest intellectual property firms in the country. They represented the Wright brothers when there were battles over their flying machines. So often jurors are called upon to learn high technology. We use clear teaching techniques that range from sort of repetition, tell them what you're going to tell them, and then tell them what you told them. Very high reliance these days on demonstratives, animations. Patent trials look like episodes of Nova. Very high use of all kinds of visual techniques, posters and animations and schematics of inventions that can be taken apart and illustrated so that jurors really can learn the technology. Because jurors are called upon to make high technology and financially complex decisions in business cases that go far beyond any of their educational prerequisites.
Is that what happened in the O.J. Simpson trial, that the lawyers for O.J. Simpson successfully educated the jury to dismiss the DNA evidence?
I think that was a part of what happened. I think that jury became scientifically astute in a way that they had not been before. And I think that was an important contribution to the outcome. I also think it was a case that really became the trial of Mark Furman, who was the racist police officer. And he became, it's very rare in a trial of one defendant that you can create a sort of quasi-defendant in someone else. Mm-hmm. But I think that happened in that trial.
And do you sit through, after you've helped to make the lawyers better educators of the jury, do you sit through the trial?
I don't. I couldn't. I have too many cases to work on to stay through the trials. But I do come and go. I come in, if the trial lasts a long time, some of the trials I work on last for weeks or months. And I'll come in one day a week and see what's happening and kind of process the information together with the attorneys. And email is actually a wonderful way to stay in touch in an out-of-sight kind of way. But I try to come to court on occasion to see what's going on. But mostly the answer to that question is no. Once the jury's picked, I'm mostly not there.
So how do you know if your education of the lawyer to become a better educator has worked? Only in the outcome?
Well, the outcome is it's a very bottom line business. The outcome is part of it. But like I said, I do come and watch, And attorneys also, particularly when they're getting ready to do their big presentations, openings and closings, will often do dry runs out of the courtroom, and I'll go and watch and see how it goes, and give them feedback at that stage to try and make them more effective as teachers, because I have the view in general, although not in all cases, but in general, that the clearer teacher wins, and litigation is ultimately that kind of business.
So justice doesn't ultimately prevail?
More often than not, I think it does. It's an imperfect system, but it's a very good system compared to what exists around the world. I think the problem that we see is that there is an extent to which any system that exists in a culture has political aspects to it. Judges are tremendously influential in a way that's sort of silent but overwhelming. And so trials happen in different kinds of ways depending on which judge tries the case. And that can make a great deal of difference in the kinds of evidence that gets aired at trial and in the jurors' impressions of what the case is all about.
Well, this is very interesting. We could continue to talk for a long time, but I'm sorry we're out of time. My thanks to Julie Blackman for joining us. For the City University Graduate Center and Women to Women, I'm Frances Deegan Horowitz.